You policemen are all cowards! You betrayed us!
Over the past few months, the United States has seen a surge of firearm embracement amidst the many challenges of 2020, like the COVID-19 pandemic, the killing of George Floyd, and the presidential election. Protests have been erupting in cities across America, and many of them involve mass gatherings of armed citizens. Americans on the left and the right both argue the constitutionality and morality of firearm ownership, and more so, weapons at a public demonstration. Supporters frequently cite the Second Amendment as a blanket justification and protection for armed protest. However, the legislation surrounding gun ownership in the United States and the Second Amendment itself are frequently misunderstood. So does the Second Amendment really protect the citizen's right to an armed protest? Let's get into it. Before we get into today's video, I'd like to make a few disclaimers. This video is not intended to persuade you, the viewer, into being pro or anti-gun, and your personal beliefs surrounding the Second Amendment or gun control are your own. My intent is to explain the Second Amendment and assess if it can be used to defend what happened at both the Capitol building in Michigan and during the Kenosha unrest in Wisconsin. Is the Second Amendment good or bad, and are these actions protected by the Second Amendment, are questions that can be answered independently of one another. I'm going to argue that while the armed protest in Michigan was lawful, it would be dishonest to claim that they were completely protected and justified in doing so because of the Second Amendment. I am also arguing that the actions perpetrated by the Kenosha shooter are indefensible, a clear breach of the law, and not at all protected by the Second Amendment. If you currently disagree with my stance, I encourage you to please continue watching this video and listen to my argument. Whether you agree with my claims or not, I really appreciate your time today.
They've grown up with the understanding they could have a pistol at home for self-defense purposes.
I'd like to start things off by looking at the law itself. The first step in understanding the Second Amendment is to, well, read it. I'll also be going over 3 important U.S. Supreme Court cases regarding the Second Amendment, and all 3 use the final version from the Bill of Rights that reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed." Right off the bat, you can see that it says, "The right of the people to keep and bear arms shall not be infringed." So I guess that's it, right? Well, no, otherwise, what would be the point of this video? There's a good bit of context behind this amendment that needs to be taken into account. During the writing of the Constitution, the Founding Fathers understood that the colonies were seceding from one of the most powerful empires on earth, and that retaliation was expected to say the least. The U.S. did not have a standing army yet, so the next most logical form of security from foreign powers was to have state-run militias. Seems pretty simple, right? But this is where a good deal of confusion regarding the Second Amendment begins. If we revisit the first half of the amendment, it reads, "being necessary to the security of a free state." This is frequently misinterpreted to mean citizens should be armed to protect themselves from the state, when in fact it states citizens should be armed to protect the state. There is no mention here of individuals having the right to own firearms for their own protection, and leads us into the first important Supreme Court case. In 1873, an armed white militia attacked black freedmen who had gathered at a courthouse in Colfax, Louisiana. Although some of the freedmen were armed and initially defended themselves, it is estimated that 100 to 280 of them were killed, most of them while surrendering and 50 of them while they were held prisoner that night. It goes without saying this terrible hate crime needed to be addressed swiftly, and some members of the white mob were indicted and charged under the Enforcement Act of 1870. The charges included violating the freedmen's right to lawfully assemble, vote, and bear arms. 3 years later, during United States v. Cruikshank, 1876, the Supreme Court ruled that the Constitution did not grant the individual the right to bear arms. Instead, it is written as to not be infringed by Congress, and its only effect is to restrict the federal government's power. This is not a right granted by the Constitution. Neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress. This is one of the amendments that has no other effect than to restrict the powers of the national government. Unfortunately, this ruling reversed criminal convictions for the civil rights violations committed by white mobs during anti-Reconstruction murders of the time. Chief Justice Morrison Waite overturned the convictions of the defendants on the grounds that the First, Second, and 14th Amendments only restrict the power of the national government and that the freedmen needed to be protected by state courts. This ruling was a huge attack on the freedmen's First and Second Amendment rights and set a precedent that allowed Southern states to continue to use paramilitary force to suppress black voting. It was the first major mention that the Second Amendment isn't a wild card for gun ownership, but instead a limitation imposed on the federal government. This idea is explored further in the next Supreme Court case in 1939, United States v. Miller. Jack Miller and Frank Layton were both indicted on charges of unlawfully and feloniously transporting an unregistered double-barrel shotgun that had had its barrel cut to be less than 18 inches in length. This was made illegal by the National Firearms Act, or NFA, of 1934, which Miller and Layton claimed was unconstitutional. The court ruled that the NFA was in fact not unconstitutional and did not violate the Second Amendment. The reason being because the weapon in question, a sawed-off shotgun, has no reasonable relationship in the preservation or efficiency of a well-regulated militia. This is a clear example of gun control that dates back over 80 years, something that's frequently criticized by pro-gun advocates of today. Americans often forget that the Second Amendment has clear limits and that it isn't an all-access pass for any gun. The Public Safety and Recreational Firearms Use Protection Act of 1994, or Federal Assault Weapons Ban, defined the term assault weapon as semi-automatic rifles, pistols, and shotguns that had two or more certain features from a list. I'll put that list up for each one since they're all kind of long. But the main point is that the Second Amendment doesn't state which firearms are allowed to be owned by the individual, and the state and federal governments still have the right to impose certain gun control measures. The Second Amendment does not protect someone from owning a firearm deemed illegal by the state or federal governments. This idea makes sense, but things get complicated when you regulate who can own a gun and for what reason. In 2008, arguably the most important case regarding the Second Amendment took place, District of Columbia v. Heller. The court ruled that the Second Amendment does protect an individual's right to possess a firearm unconnected with service in a militia and to use that arm for traditionally lawful purposes. This ruling was in response to D.C.'s handgun ban and requirement that all lawfully owned rifles and shotguns be kept unloaded and disassembled or bound by a trigger lock, which was found to violate the guarantees of the Second Amendment. This was huge for the U.S. because now a citizen could legally own a firearm regardless of militia service. For the first time, owning a gun just because you wanted to was a protected right. However, this ruling firmly rejects the absolutist misinterpretation of the Second Amendment. Any gun, any time, anyone. So while the court did uphold that the individual could own firearms, it also specifically mentions that there are rules, restrictions, and limitations to the Second Amendment. This now leads us into the events that transpired in Michigan.
Open the door! We have a right, let us in.
On April 30th, 2020, several armed protesters entered Michigan's Capitol building demanding an end to Governor Gretchen Whitmer's shelter-at-home order. They were allowed into the building but were denied entry to the House floor by the chamber's sergeant-at-arms. Aside from the increased risk of COVID-19 transmission, many people questioned the legality and safety of such a large armed force in a public building. In a document written on May 11, 2020 by Michigan's Attorney General Dana Nessel, she affirms that the Michigan State Capitol Commission had not imposed any restrictions on firearms within the Capitol building. I'll include a link below if you'd like to read the full document. The lack of such restrictions led to armed citizens gathering in public galleries above the chambers of legislature. This situation, as it is currently presented, has two major issues. First of all, armed protesters were not screened upon entering. The citizens needed to be open carrying unless they have a concealed pistol license, or CPL, but that's it. you inevitably run the risk of someone entering the building with other weapons, like incendiary or explosive weapons, and potentially causing a lot of harm to state officials and to other protesters. And second, armed protesters gathered during a controversial debate within the chamber, and combined with passionate and emotional chanting, this becomes a very dangerous situation. You have several armed citizens furious with what the governor was doing, yelling at members inside the chambers and demanding she not extend the lockdown. Supporters of the protest argue that they were protected by the Second Amendment to carry firearms and protest on Capitol grounds. Well, that happens to not be the case. Remember that in U.S. v. Heller, the court held that the right secured by the Second Amendment is not unlimited. It does not protect the right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. The court also recognized the validity of laws forbidding the carrying of firearms in sensitive places. This includes all government buildings and, yes, the Capitol. The state of Michigan even states that open carrying does not give you the right to bring any guns into any public space for whatever reason. Under Michigan state law, it is illegal to carry a firearm into schools, daycares, sports arenas, courts, places of religious worship, entertainment facilities that have a seating capacity of 2,500 or more people, hospitals, and college dorm rooms, even if you hold the CPL. I'll also include a link to the full list if you live in Michigan or would just like to check it out. This isn't an infringement of the Second Amendment, as we've seen before in 1939 and 2008, because again, it protects your right to own a gun, not to do whatever you want with it. The other important point to make regarding this situation, and ultimately the point of this video, is intent. You need to question the motives surrounding the protest and how protesters aim to achieve their goals. Why are you armed? Is your safety or the safety of others at risk? Or is it to intimidate the state legislators? The Second Amendment protects your right to use a firearm for traditionally lawful purposes, like self-defense in your home. Most people with a permit to carry a concealed weapon, a CCW, or a CPL for Michigan, will tell you that they carry it in case of self-defense. The key issue that bars what happened in Michigan from being protected by the Second Amendment was the nature of the protest. They were demanding that the governor end the lockdown, effectively coercing members inside the Capitol building with their firearms. Let me be very clear. If there is only one thing you take away from this video, let it be that the Second Amendment does not protect you from committing threats of any kind. Threatening someone with a deadly weapon is still a crime, even if no firearm is discharged. No verbal threats of violence with a weapon were made during the protest in Michigan, hence why people were lawfully allowed to enter, but firearms weren't needed in this protest. You could have had people gather in or outside the building chanting to end the lockdown. So what is the need for a gun? The easy and dismissive answer is, of course, because I can. But that ignores the very apparent answer, because guns are frightening and send a clear message. It's the "don't tread on me" mentality. When you see someone else carrying a firearm, your first thought isn't, "oh, I feel safer now." It's instead, "I want to avoid a conflict with them." When you engage in an armed protest that has no need for firearms, you inadvertently send the message of "listen to us or else." That is a threat, albeit only implied, but still just as serious. On August 25, 2020, 17-year-old Kyle Rittenhouse shot 3 protesters in Kenosha, Wisconsin, 2 of which died. The protests were sparked after Kenosha police shot Jacob Blake 4 times in the back on August 23rd. The police were responding to complaints of domestic violence by Blake, who was unsuccessfully tasered and subsequently shot. According to his attorneys, Rittenhouse had heard that the owner of a local car dealership wanted help defending said dealership. Following this, Rittenhouse and his friend Dominic Black armed themselves with rifles and went to the dealership. When asked why he was there by Daily Caller reporter Richie McGinnis, Rittenhouse responded by saying, "So, people are getting injured, and our job is to protect this business. Part of my job is also to help people. If there is somebody hurt, I'm running into harm's way. That's why I have my rifle, because I have to protect myself, obviously. I also have my med kit." Right off the bat, we can identify a couple of clear instances where the shooter broke the law even before said shooting. Possession of a long gun by someone under the age of 18 is against federal law and against Illinois and Wisconsin state law. Transporting a firearm across state lines by someone who is not a lawful gun owner and for non-lawful purposes is also against federal law. Those aside, the critical part of this incident was the unlawful shooting of 3 protesters and the subsequent death of 2. Those who defend Rittenhouse's actions do so by claiming the self-defense argument and that the Second Amendment protects his right to open carry. D.C. v. Heller established that firearm possession is justified when used in a lawful manner, but nothing about Rittenhouse's actions constitute as self-defense. The shooter deliberately put himself in an unnecessary situation and radically escalated the risk of danger by bringing a firearm. This wasn't something like a home invasion. Instead, the shooter went to another state to participate in something he had no business participating in and brought with him a weapon he could not lawfully possess. In other words, this wasn't a case of righteous self-defense against violent protesters. It was a case of role-playing the vigilante. He only escalated the situation by bringing and brandishing a gun in public and made the environment substantially more dangerous when it wasn't called for in the slightest. To put it more simply, this wasn't self-defense. It was premeditated domestic terrorism. This goes back to what I said previously about intent. What was the intent of the shooter, and why did he believe illegally bringing a gun to a mass protest was the righteous thing to do? It highlights one of the biggest problems surrounding guns in the United States: the glorification of gun culture and ignorance surrounding the law. While many people who consider themselves to be conservative may defend Rittenhouse and his actions, the bottom line is that this situation could have been entirely avoided. All of the events leading up to the shooting only further increased the risk of danger for everyone attending or in the vicinity of the protest, and culminated with 2 homicides and 1 attempted homicide. Some may be inclined to believe that he was doing the right thing by trying to protect a small business. Again, that wasn't his job or his place, but it did enable him to cosplay as a police officer by using a firearm to coerce and deter protesters. His actions simply agitated the protest, and in no way did his possession, let alone use, of a firearm help ensure the safety and security of other people. Just like what we saw in Michigan, the Second Amendment is grossly misinterpreted, if not completely ignored in this situation. The right to bear arms has been very up in the air for most of American history, but D.C. v. Heller helped clear a lot of that fog. The Second Amendment protects your right to own a lawfully acquired firearm and use it for traditionally lawful purposes, but again, it doesn't protect your ability to do whatever you want with it. There are still limits that are indeed deemed constitutional by the Supreme Court. By using this amendment to justify and enable domestic terrorism, not only do you undermine its intent, but you also delegitimize the Constitution. The Second Amendment is a very misunderstood amendment in the U.S. Constitution, and to argue its legitimacy is beyond the scope of this video. Regardless of your views on it, what I really want to emphasize is that the Second Amendment cannot be cited as justification for the armed protest in Michigan or for the shooting in Wisconsin. Michigan state law is clear about where and when you can possess a firearm, and it was legal for protesters to open carry without a CPL inside the Capitol. What I want to get across is that the Second Amendment is not what gives the protesters the right to do so. Michigan state law directly states that one may open carry inside the Capitol, but they are also fully within their rights to make it illegal to do so, and it wouldn't be a violation of the protesters' Second Amendment rights. As for Wisconsin, what happened was a series of illegal events perpetrated by an adolescent that led to the death of 2 people. He broke both federal and state law to play the role of a police officer at a protest and create a much more dangerous environment. You can't break the law, commit a serious crime, endanger protesters recklessly and without necessity, and claim self-defense protected by the Second Amendment. Those actions are not protected, and the shooter should be held fully accountable for his crimes in Wisconsin. So those are my takes on the armed protests in Michigan and the shooting in Wisconsin. I don't believe that protesters were justified in claiming protections under the Second Amendment. I would classify both of these events as acts of domestic terrorism since both involved the use of firearms as a deterrent or as a form of coercion and intimidation. Do you think these protests would have been as effective without the presence of firearms? Let me know what you think, as I love to see what other people have to say about this topic. And that concludes this video on the Second Amendment. I really enjoyed making this video, and I hope I could shed some light on the legal context around gun laws in the US. If you enjoyed this video or learned anything new, then please consider giving it a like, and thank you all for tuning in today.